नमस्कार. गोवन वार्ता लाईव्हच्या टू द पॉईंट कार्यक्रमात मी किशोर नाईक गावकर आपलं स्वागत करतो. गोंयकारपण, गोवन ओरिजिनॅलिटी आपण कसं राखून ठेवणार यावरती बरीच चर्चा यापूर्वीही होत होती आणि आताही सुरू आहे. आता गोंयकारपण आपण कसं राखून ठेवणार आहोत. गोव्यात ज्या पद्धतीनं स्थलांतरितांची संख्या वाढते आहे, स्थलांतरितांना आता कसं रोखता येईल यावरती चर्चा होण्याची गरज आहे. विनाकारण या लोकांना आपण परराज्यातील किंवा घाटी असं संबोधून जर त्यांना नाकारण्याचा प्रयत्न केला तर हा प्रश्न खरोखरच सुटू शकेल का. मुळात स्थलांतरितांची संख्या किंवा स्थलांतरितांचा आकडा गोव्यात का वाढतो आहे याची कारणे शोधून त्यावरती उपाययोजने हेच खरं म्हणजे त्याच्यावरती उत्तर असू शकेल. आता महत्त्वाचा विषय म्हणजे गोंयकारपण जर आपल्याला राखून ठेवायचं असेल तर त्याचं मूळ हे गोव्यातली जमीन आहे. आपली नाळ म्हणजे गोंयकारांची नाळ ही या जमिनीत रुतलेली आहे. त्यामुळे जर ही नाळ तुटली तर मात्र गोंयकारपण शिल्लक राहणं किंवा गोंयकारपण टिकून राहणं हे खूप कठीण बनू शकतं. जुवारीचा विषय असू द्या, जमीन विषयक इतर मुद्दे असू द्या, या सगळ्या विषयावरती आम्ही आज चर्चा करणार आहोत. आणि आमच्यासोबत आहेत ॲडव्होकेट आंद्रे पेरेरा. ॲडव्होकेट आंद्रे पेरेरा हे एक सिनियर काउन्सिल आहेत, ज्येष्ठ वकील आहेत आणि विशेष म्हणजे गोव्याच्या जमिनी संबंधीचा सखोल अभ्यास त्यांनी केलेला आहे. एक विशेष गोष्ट ही मुलाखत जे नीज गोंयकार बघत असतील त्यांनी एक गोष्ट लक्षात ठेवण्याची गरज आहे की गोवा जेव्हा पोर्तुगीज राजवटीखाली होता त्यावेळेला गोव्याचा कारभार, गोव्याच्या जमिनींचे व्यवस्थापन हे पोर्तुगीज कायद्याप्रमाणे होतं. परंतु गोवा जेव्हा मुक्त झाला त्यावेळेला याच गोव्याचा कारभार हा भारतीय कायद्याअंतर्गत आला आणि भारतीय कायदे हे ब्रिटिश कायद्याअंतर्गत ब्रिटिश कायद्यांचा प्रभाव असलेले कायदे होते. त्यामुळे या कायद्यांच्या घोळात अशी परिस्थिती निर्माण झाली की गोवा मुक्त झाल्यानंतर तत्कालीन नोकरदारांनी ब्रिटिश कायदे लागू केले, म्हणजे तत्कालीन भारतीय कायदे लागू केले आणि त्यामुळे अनेक नीज गोंयकारावरती अन्याय झाला. या अन्यायाला वाचा फोडण्यासाठी आतापर्यंत अनेक प्रयत्न झाले परंतु ते कुणीही ऐकून घेण्याच्या मनस्थितीत नाहीत. याच नोकरदारांनी राजकीय नेत्यावरती आपला प्रभाव टाकला, त्यांना आपल्या ताब्यात घेतलं आणि त्यांच्याकडनं वेगवेगळे कायदे तयार केले. परंतु हे कायदे पोर्तुगीज कायद्यापेक्षा वेगळे ठरले. आजही जेव्हा गोवा भारतात सहभागी झाला त्यावेळेला एक करार झाला होता आणि त्या करारात स्पष्टपणे सांगण्यात आलं होतं की पहिल्यांदा पोर्तुगीज कायद्याप्रमाणे लोकांना न्याय देण्याचा प्रयत्न हवा आणि त्यानंतर भारतीय कायदे लागू करण्यात यावेत. जमिनीच्या संदर्भातले जे कायदे आहेत ते पोर्तुगीजकालीन कायदे आहेत. परंतु गोव्यात लँड रेव्हेन्यू कोड अधिसूचित करण्यात आला आणि तिथून हा जो घोळ सुरू झाला तो आजतागायत म्हणजे 60 वर्षे पूर्ण करून हा घोळ सुरू आहे. Sir, I welcome you for this interview. At the beginning, you know what the Zuari land scam is. 50 lakh square meter of land given for a specific purpose. It is an comunidad land of Sankwal comunidad. Now the purpose is defined. The factory which has been established there have been already sold by Zuari company to some other company. But the land given to Zuari claims that they are the ultimate owners of that land and government is saying that we can't do anything now, the land belongs to Zuari. Can it possible?
No sir, the land of Zuaris was come from a proposal at that time when first CM was there to grant that land based on Code of Comunidad. Now in the Code of Comunidad there are only two places where you can grant land, that is for agriculture purpose, the minimum area, and the limited area, that time not more than 1,000 for housing purpose, and there was no other purpose. Now what has happened before that, I remember that many general body was called, that general body of Sankwal Comunidad rejected. Some people influenced the managing committee to give some consent, overruling the managing general body and that went to government for approval. And that government approved the land that was reserved for cattle grazing ground, which Article 325 totally objects to it, that is prohibited. You can't give lands for agriculture, that is grazing grounds for any purpose, whether it is agriculture or for housing purpose. This is the land, I think it was more than 700 acres. And that was the land which was now, after this survey which is come, that was prior to that, after that survey, I think they have captured more area around and they made use of this record of right and plan to capture more area. Now the thing is that, as I was saying, the grant was made under lot number so and so, reserve lot number so and so, not under the code. So now they have done it such a way that they have adopted the survey record under land revenue code when the land was never granted on land revenue code. Now, slowly, as you say, I came to know that Beats Pilani, for that large area of land is alienated by Zuari from the same land. Then comes that tanks, petrol tanks and things which were made. For that also that area is given. Beside that, they have dealt with some private exchange of lands with some people, allowed some people to carry out the road which has gone. They have collected the compensation, that highway, bypass road, as if they are the owners of land. No ownership. The law is very clear in the code. It is only possessory right, and that right is only for utility for the purpose granted. Now the Kundan is being cheated not by Gaonkars or shareholders, it's cheated by the government. The government who has approved the grant which is contrary to the code is bound to return that land, evict all those Zuaris, because there is no land under Zuari given by land under land revenue code. Article 648 of the code is very clear that it is the government duty to clear it. The government cannot wash hand. No, they have become owners. No one can become owner of the land. They are only temporary possessions for the purpose is granted. Now, as we say, that purpose for which granted is been violated. Under the old law, when there is a violation, there should be forfeiture of that grant. Now that grant, whether they made 20 times payment or not, it amounts to, it is coming to forfeiture. Now that whole entire thing has to be forfeited. The government cannot watch hand saying that no, some court orders have been, court cannot give ownership document to a land which belongs to you. The court can only declare whether it has ownership document. Now we have never surrendered ownership. It was only possession. So the minister has not shown where are the orders of the court that the law department says they have got several orders. You can't have several orders. There can only be one order whether Zuari is the owner or not. So how you can get several orders? There was one plot given, one lot number, reserve lot. For that reason, the cows and buffaloes which were freely grazing on land have died on the road, created accident. People have died on that road because of this. Besides, Zuari has pumped so much of urea into the river, in that spring was there. That spring also is destroyed with the, I don't get the name, which is going down to Sankwad side to the river, Dharwad or something. That spring was healthy spring. People were going there. It is polluted. It was just like Kesarwad spring, totally polluted. People have dug their septic. There are bore wells which are done. The entire air belt around Sankwad, Kansauli, Welsam, the wells have been destroyed because there is seepage of this urea into their water. That is why they have many cows and buffaloes by drinking that water died at that period of time. And this is the situation. Now, government cannot go back. Government has to restore that land back.
Sir, one thing that government says, Zuari has deposited the money to the comunidad and they have got the ownership on that land. Can it be possible?
No, that deposit only to forego the yearly liability to pay for, and that is by 20 payment he is only liability to exempt himself. That is the redemption of the 4. It is not payment of the cost of land. That for even that payment, by the manner in which they have done, there is a whole, the law of emphasis comes into force, by which they have to forfeit the area of the land and forget about that 20 times. The land has to be restored back to community.
50 lakhs square meter of land was given to Zuari at that point of time. Now, out of that 50 lakhs, Zuari has used something about 5 lakhs square meter land for that unit of their manufacturing. Then other land is being used for various purposes, but still then there is lot of land
Yes.
vacant there.
Yes.
Now, is it possible that government should acquire that land?
Not acquire, forfeit it. Forfeit it, no. Issue notice to Zuari that they, because see, it is not the comunidad who surrender that land. It is the government which made to hand over that land to Zuaris. So the government is entirely responsible for the consequences. Not comunidad, it is against the wish of the comunidad that the government has gone and handed over that land to them.
Can you just tell me, when Portuguese moved out of Goa, at that point of time, is any land belong to Portuguese government which they have surrendered to Indian government? Is there any ownership of land of Portuguese government when they moved out of Goa?
Portuguese government never owned any land which has been declared in 1510 under that foral, with the contract which was understood that the earlier rulers, maybe Adil Shah and before that other rulers, they were here as only guardians of the indigenous people, and it was said that they are the owners and not the state. State rulers were only guardians to protect life and property and not land. So all this while, all these years during Portuguese rule and prior to Portuguese rule, land revenue was not collected. The Supreme Court, while passing that judgment in 1967, when it was dealing with the Daman abolition, have recognized that the Goa never have lands belong to the state on tenure basis. That means there no lands belong to government. What they had is lands which were forfeited for non-default of non-payment of for and taxes and things like that by those comunidad who were defaulted in payment. That means attached land, and those attached lands are gone for under the decree 2003-062, where from there alvaras were issued, actually to whom those people who were already there before dissolution of the comunidad, people were existing there centuries before that act came. That alvara is only recognition that you are their holder and you have to pay so much to government. And the government is more interested in revenue or taxes from you. They are not bothered about who, but they know from whom to collect. So now that alvara is only a sort of a order recognizing that you are their lawful possession. Since number of years, now that was shown. If you go to see, this is only say that you are under contract of affirmation before the government. So now what I am saying, government doesn't have any land succeeded from Portuguese government to be their owner. At least in 226 Comunidad, it is already declared under that diploma 1961, saying that government is not owner of any land in the revenue village. I understand, that means Comunidad villages, and I understand before this all that period, at the beginning when Portuguese rule was, there were over 500 village bodies, Gaonkar is here, of which slowly what has happened is some default is there, they are things abolished, and all those abolished lands have fallen in custody of the government. They are not owners, they were only custodian. And that custody is now expressed in Article 648 that they want to re-establish, reconstitute the comunidad of whose land they have in possession. That has taken place just before liberation of Goa. But that part has not been complied by this present government. That obligation is still there. So that's why I say, where government has made fault, by which people have suffered, by which lands have been taken away to be handed over to some authorities or some businessman or company, that is not by community, that is by forceful handing over the land. Now, as you say, Zuari is having land by forceful dispossession from community by the law. Your government itself has done it. The government cannot now wash hands. You have to return it back because the fault is of the government, not of the people who had done. That's why you can't wash. No, we can't do anything now. It is not. The Article 648 calls upon them to restoration.
Sir, one more thing. Now this Alvara issues, what you have mentioned, is a very old issue. It's from before liberation. Then after Alvara lands were with the allottees. Then after liberation, government came out with an order and they have reverted several Alvaras. I think 450 or 500 Alvaras out of 8,000 were reverted. 11,000 Alvaras. Then after one person went in High Court and he got an order that government cannot revert the Alvara. Even then, government has not made any to give these Alvara lands to the allottees. They are still not decided, and people cannot get various agricultural schemes for that Alvara property. They are saying that it is a government land, and for government land, government cannot give agricultural scheme. Why these Alvara issues been not resolved as of now?
See, if you go to see, that judgment is given in the case of that Goan Raiturkar, okay? That Goan Raiturkar was actually not a grantee of Alvara. He was a person who the Alvara holder sold it to him. And there is a provision there where you have confirmed with that final possession. There is a provision there that you can transfer it to somebody provided you take cognizant endorsement from the governor at that period of time. So the High Court has found that this law of granting was a purchase law and it was not land revenue code. Okay. Now that order of reversion in that case was taken by collector somewhere in 1969 or something. And the court found that the collector is not an authority appointed under the old purchase law, but he is appointed under the code of land revenue code. As I have mentioned to you, he can do only transaction or deal with the land which has been granted under land revenue code and by rules of 1971. That is clearly mentioned by in that judgment and said that reversion cannot take place in the hands of the collector because that reversion have procedure under that decree, and that period for reversion and all has been long lapse if it was in deficiency, because the period for reversion was 10 years and then fulfillment of condition, everything was over by that time. So the court found that there is no case for reversion and at least the collector doesn't have jurisdiction for reversion. Now what I am trying to tell you, when the law of code of land revenue code is not applicable to the Alvara land holdings, in that case revenue authorities foreseen on the land revenue code will have no jurisdiction even to carry out survey or make your record of rights in that, because you already have record of right, you already have a plan under that Alvara, and that identify your thing because that is a piece of land granted to you under Alvara. that piece of land is intact with you. The interference is in breach of that. It is a contempt on the court by the revenue authorities to again interfere. You have not reverted, you can't revert it. But at the same time, we have no jurisdiction over it because it is already declared that the collector and revenue authorities appointed on the land revenue court have no jurisdiction over this land holding. Now you must understand that when there is no jurisdiction over land holding, then all these authorities cannot say that you are an illegal occupant. That I have showed you the Act of 2000, which was passed in 2014. The Section 3 is very clearly saying that Alvara landholders are proprietors, and that proprietorship is not abolished, whereas in other cases it has been abolished. Of Alvara is not been abolished. It is very clearly shown that you are a proprietor. A proprietor cannot become a occupant. An occupant is shown there who has become only after abolition of proprietorship one can become occupant, which is recorded in Form 114 or that 20. The whole thing is we are not interested in telling the government that you have no jurisdiction under this law.